Buckle up, guys. Today we are diving into a custody battle that starts with a powerful claim. Right out of the gate, the father is painted as the backbone of the household, the go-to parent for 7 years, the one who shut down his own business just to raise his kids. That opening doesn't just introduce a case, it frames a sacrifice. And in family court, whoever controls that first narrative often controls the tone of everything that follows.
Plaintiff, Ms. Thomas, on behalf of defendant, this matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Capture.
Thank you, Your Honor. I won't go through the process of repeating what was in our motion and complaint. However, I do want to address defendant's answer directly. First and foremost, defendant describes an incident that occurred in 2023. However, the description in defendant's answer is incorrect. Defendant took plaintiff's phone on a Thursday evening after plaintiff had worked a 12-hour shift. He then taunted and laughed at plaintiff after she requested that he put her phone down. He then ran into the bathroom and locked himself in with plaintiff's phone so that he could go through it. Obviously, plaintiff was upset about this. She exited the home to cool off, and instead defendant took himself and the minor children and went up to a window and essentially just taunted plaintiff. Unfortunately, this type of behavior has continued now into this next year, where the two parties should not be within the home together. So plaintiff made the decision to leave the home. She has been getting parenting time essentially every single day. She does work 40 hours a week with 12-hour shifts. Our parenting time schedule that we have requested includes overnights because defendant has absolutely refused to allow plaintiff to have overnight parenting time.
Now the mother's attorney steps in and flips the script. We hear about a 2023 phone incident, accusations of taunting, and a home environment so tense she felt forced to leave. She denies substance issues and pushes hard for overnights and joint custody. This isn't just rebuttal, it's a counterattack. The strategy is clear. Challenge credibility, soften the allegations, and reposition her as a working mother simply fighting for equal time.
And stated on multiple times that he would not even allow plaintiff to see the minor children if she did not return them home, despite the fact that plaintiff does have adequate housing for the children to stay with her. Again, plaintiff is full-time employed. She does not have an issue with marijuana or whiskey, as defendant alleges. Defendant grew marijuana for a long period of time. I don't believe he does any longer. However, both parties have abstained. Plaintiff is no longer utilizing prescription drugs. She has abstained from those as well. With the Wellbutrin and the Adderall, they have been prescribed to her. However, she's no longer using those. Again, Your Honor, plaintiff is a loving and caring mother. She has a great relationship with her two children. Defendant has prohibited her from having adequate parenting time with her kids. Due to her work schedule, she believes that the requested parenting time, 4-3 parenting time, is an adequate parenting time schedule, with both parents sharing joint physical and legal custody. The parties are able to agree on legal issues. There doesn't seem to be any issue with regard to that with the minor children. Thank you, Your Honor.
Okay, thank you. Ms. Thomas?
Thank you, Your Honor. I think it's important to note a couple of things. Well, first of all, it's notable, I think, that it appears that plaintiff's counsel just admitted that although the plaintiff is prescribed medication, she's not taking that medication. So that's a little bit of an even greater concern.
Now things escalate. The father's attorney doesn't just defend. She raises alarms. Medication not being taken. Alleged drinking. Statements about not wanting to be on Earth anymore. That's no longer about scheduling. That's about stability. When children's demeanor changes get mentioned, the courtroom tone shifts. These are the kinds of claims judges take seriously because they move the case from preference to potential risk.
The two children are 9 and 3. They separated approximately 2 months ago, And since that time, the children have resided with defendant father. He's ensured that the plaintiff mother has had daytime parenting time approximately 5 days a week, and now with her latest change in her work schedule, about 4 days a week. The schedule did change a couple of times. First, when the school started, so that the kids came back earlier, and then now mom's working different days. So currently, parenting time is based upon mom's work schedule, and she now works 12-hour shifts on Monday, Tuesday, Wednesday, and then a half a day on Thursday. So she gets Rosie at about 1 o'clock on Thursday, and then picks Cam up from school, and then dad picks them up between 7 and 7:30 on Thursday, and then on Friday the schedule is the same, other than he picks them up between 8 and 9. Saturday she has both kids from like 1 o'clock until 9. The parties, we disagree that the parties have effectively co-parented during their relationship, and for the reasons detailed in defendant's answer to the motion, plus the fact that plaintiff has told defendant and acknowledged the defendant that she is aware of her drinking problems. She is aware that she drinks, or that she smokes too much weed. She said she doesn't want to be here anymore. And when asked about well, what do you mean? And she said, I don't want to be on earth anymore. I mean, there's some things going on with mom that we need to make sure are taken care of before we put the children in a situation. And we think that the extended, longer periods of parenting time are the problems. And the kids, they don't want to go. Their demeanor changes when it's time to go. When they...
Here, the defense doubles down on the father's role. He wasn't just involved. He was primary. He closed his business, became full-time caregiver, managed everything. The message is deliberate. This is the stable parent. When courts evaluate custody, continuity matters. By reinforcing years of hands-on parenting, the defense is building a foundation that says disrupting this structure could harm the kids more than maintaining it.
They're excited to come home. They report all kinds of things, obviously, that I'm not, at liberty to state right now, but certainly I've heard some things that they've said that is very concerning to me. And we're asking that the current parenting time schedule continue the status quo until such time as the parties can either participate in mediation and or an evidentiary hearing is held, and or plaintiff mother addresses her alcohol abuse and mental health issues. It is notable that plaintiff mother's requested parenting time plan would not allow defendant father any full weekends of parenting time, which would not be equitable as far as that goes. Defendant father agrees that for stability, the children do need a temporary order. It is necessary. However, it should be a continuation of the current schedule. During the parties' relationship, they were not equal when it came to caring for the children. Defendant father was the go-to parent for the children and oversaw their activities, assisted with homework, prepared meals, oversaw medical appointments in his role as a stay-at-home father, which he's been for the last 7 years. Once he realized, and he did that once he realized the extent to which the plaintiff mother, she was supposed to only be working part-time, then she went full-time without discussing it, and he couldn't do his business out of his home and do everything for the kids too. And when she got pregnant for Rosie, and then had the baby, he couldn't take care of a toddler and run his business, so he closed his business to continue in the role of a stay-at-home father. Her use of alcohol and her habit of using, and I understand what counsel said, but her use of marijuana and continued drinking while she's on prescription meds and then now not taking her prescription meds is very concerning. It's concerning that both because what does that do to her mental health issues, but also that it's just at a situation where it's very concerning about what has happened. She's very rough with a 3-year-old, and it's very concerning. Defendant father was hired by Duncan Aviation last week. He starts in a couple of weeks, and once he gets his first paycheck, of course, we think that child support should be set pursuant to the Michigan child support formula. That's fine. But in the meantime, we're asking that.
And then the accusations intensify. Claims of being rough with a 3-year-old, requests for psychological evaluations, concerns from siblings. This is the emotional peak. When a toddler's safety is mentioned, it immediately raises the stakes. The father's side isn't just arguing for more time, they're arguing for protection. That's a powerful pivot, because once safety enters the conversation, equal parenting becomes secondary.
Due to the ongoing health and alcohol abuse issues, by plaintiff mother, the defendant is requesting sole custody with parenting time as described. And then we're also requesting an order for a psychological evaluation and drug alcohol assessment for the plaintiff with the requirement that any treatment recommendations be followed. We're just very concerned about the safety of this, especially, I mean, the older one is 9 and he's old enough that, you know, he can tell you, but she's 3 and it's very concerning. It's very concerning that not only what her brother says, but that her older sister, who is actually the plaintiff's daughter and not the defendant's daughter, but has chosen to live with the defendant. It's very concerning that some of the things that they are reporting that happens, and how rough that mom is with Rosie, who is again only 3. We're simply asking that we look out for the best interest of the child and make sure that she's safe and secure in a stable environment. And therefore, our request is as we've stated, but specifically with a parenting time as currently has been happening.
Okay, thank you. Well, the court notes there's a lot of allegations, and again, that's preceding this case. But the fact is, the parties have noted, and the defendant has noted as well, that the plaintiff has been receiving the children either 4 or 5 days per week, just not in the overnights. So the court's taking that into consideration to show that the children have spent a substantial period of time with her. What the court's going to do on a temporary basis to preserve that, court is going to grant to the parties joint legal and joint physical custody, and the court will award parenting time as per paragraph 15 of the defendant's or plaintiff's motion, which would be a 4-3-3-4 schedule, as well as alternating holidays. And court will set the support based upon the income of the parties. That's the plaintiff has stated that she's making $47,000 per year, and now the defendant is making $24 an hour. A court will order that the parties would meet at a 1/2 half point between their residence to exchange the children.
Now the judge steps in, and you can feel the temperature drop. She acknowledges the flood of allegations, but focuses on one undeniable fact. The mother has been seeing the children 4 to 5 days a week. That detail cuts through the drama. Courts often preserve what's already functioning. Instead of reacting emotionally to accusations, the judge signals she's looking at consistency and the children's ongoing relationship with both parents.
And I'll leave that up to the attorneys to work out where that one halfway point will be, and would order that the parties would abstain from alcohol or non-prescription drug use during the time that they have the children in their care. That will be the extent of the order. I'll ask Ms. Capture that you would prepare that. You can submit under 7-day notice.
Thank you, Your Honor.
Okay.
Judge, I do have other cases at the same time. Do you want me to just stay on?
Yeah, we'll probably put you back in the waiting room until we can get all the parties present.
Thank you, Your Honor.
Finally, the ruling lands. Joint legal and physical custody. A 4-3-3-4 schedule. Income considered. Neutral exchange point. And a strict order. No alcohol or non-prescription drugs during parenting time. It's balanced, structured, and temporary, but decisive. The judge doesn't reward fear or accusation. She preserves stability while setting boundaries. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.